You were on the board of the New Civil Liberties Alliance, I believe, at the time when Jeffrey Clark was hired. Do you recall that hiring?
Senator, I don't know what you mean by recall the hiring. I was on the board of the New Civil Liberties Alliance and up through about July of 2021. And as I recall, what happened around that time is that, and I had a conversation with the director about it, I stopped being a board member. They were bringing litigation that involved an opinion that I had written at the Office of Legal Counsel in the executive branch, and I strongly disagreed with their stance in that litigation. It was actually bringing the opposite view. I also expressed that it was
about the hiring of Jeffrey Clark.
But I guess my point is, as a member of an advisory board, first of all, of the group, I wouldn't have had anything to do with it, and your issue has nothing to do with it.
You weren't aware of it.
I read newspaper accounts of his hiring on the New Civil Liberties Alliance. As a board member, advisory.
Contacted you to ask that you support his hiring?
No,
you weren't consulted by him? You didn't interview him?
No, it was like a 24-member advisory board. A couple of dozen people, no.
Got it.
Welcome back to the Hill Debate. Today, we dive into a heated Senate Judiciary Committee exchange where senators pressed Ms. Mascott, President's nominee to the Third Circuit, on her courtroom experience, Delaware connections, and ties to powerful conservative legal movements. The questioning became especially sharp when concerns were raised about her views on administrative law and potential bias toward fossil fuel interests. Let's break it down.
Professor Mascott, welcome. Is it fair to say that you have fairly little actual litigation experience outside of serving as amicus counsel?
Well, Senator, as I believe the Senate Judiciary Questionnaire points out, and also, actually, that was quite extensive experience with dozens of amicus briefs, sometimes for senators here. I also mentioned the background.
Amicus brief is different than actually trying cases. Have you ever tried a case, for instance, been the lead counsel in a case that was tried to verdict?
So, Senator, I believe as the letter that we submitted yesterday indicates, it was talking about the District of Massachusetts matter that I argued. It was a summary judgment and full trial collapsed into one hearing, and argued that to verdict on the Title IX Department of Education, and then also had the honor to argue in courts of appeals during my time at the Department of Justice, and have served in all three branches of government, of course.
And with respect to your connections to Delaware, have you ever voted in Delaware?
Well, Senator, as I was discussing with Senator Coons, we, of course, have had a long time home.
Simple question. I'd prefer if I didn't get filibustered and I actually got an answer to a simple question. Have you ever voted in Delaware?
Well, Senator, as a public servant and professor here, no. I've been voting in Maryland.
Registered to vote in Delaware.
Well, Senator, as a public servant and academic here, I'm registered to vote here. If this body...
Driver's license or any other record of licensing from the state of Delaware?
Senator, I do not yet have a Delaware driver's license. I do have a car that is insured in Delaware with
because you have a summer house there.
We've had a long time home, and yes.
And you were not admitted until May into the Third Circuit?
Senator, I became admitted in May in the Third Circuit, yes.
And you have no blue slip from either of the two Democrat senators, from Delaware senators?
Senator, I am really honored to be the president's nominee, and
blue slip, correct?
Well, I didn't believe there were blue slips at the circuit court level at this point for any circuit court nominees.
That was undone by our friends on the other side of the aisle, and now that is the new tradition, and I'm clarifying that you have none, correct, right?
Senator, I don't, because it's not been used for circuit court nominees.
Nomination to the Department of Education as general counsel was withdrawn when? Today?
Senator, I believe it was referenced that it was yesterday.
Yesterday, okay. You were on the board of the New Civil Liberties Alliance, I believe, at the time when Jeffrey Clark was hired. Do you recall that hiring?
Senator, I don't know what you mean by recall the hiring. I was on the board of the New Civil Liberties Alliance, and up through about July of 2021. And as I recall, what happened around that time is that, and I had a conversation with the director about it, I stopped being a board member. They were bringing litigation that involved an opinion that I had written at the Office of Legal Counsel in the executive branch, and I strongly disagreed with their stance in that litigation. It was actually bringing the opposite view. I also expressed that it was
about the hiring of Jeffrey Clark.
But that's I guess my point is, as a member of an advisory board, first of all, of the group, I wouldn't have had anything to do with it, and your issue has nothing to do with it.
You weren't aware of it.
I read newspaper accounts of his hiring on the New Civil Liberties Alliance. As a board member, advisory.
Contacted you to ask that you support his hiring. You weren't consulted by him. You didn't interview him.
No, it was like a 24-member advisory board. A couple of dozen people. No.
Got it. You constantly use the pejorative term administrative state. You have called for the repeal or the overturning of Humphrey's executor. You have called to undo Chevron deference. You have supported the so-called major questions doctrine. All of these signals are extremely important to the fossil fuel industry, which has a decades-long battle against agencies that regulate its pollution, and which is the dominant donor interest to the Republican Party, and which heavily funded the $500 million enterprise to capture the Supreme Court. How on earth can you expect anybody representing an interest opposed to the fossil fuel industry to get a fair hearing from you?
Senator, if I were to have the honor to be confirmed at the Third Circuit, as mentioned, I would be holding the role of a judge, which is to resolve fully and impartially cases and controversies, not rule on policy matters. And also, if one looks at a record, even of amicus briefs in the clinics, these are cases that are being brought on legal principles, and at times for parties that are holding different policy views. And I would continue to have the same tradition of impartiality for the rule of law if I had the honor of being confirmed.
During the confirmation hearing, Ms. Mascott faced persistent scrutiny over her direct litigation background. Senators pointedly asked whether she had ever tried a case to verdict as lead counsel. Mascott acknowledged her work on dozens of amicus briefs, summary judgment arguments, and appellate advocacy during her time at the Department of Justice, but critics emphasized that this experience differed from actually managing a trial through jury verdict. Attention then turned to her connections to Delaware, the jurisdiction where she would serve. Senators questioned whether she had ever voted in Delaware, held a state license, or otherwise established residency beyond teaching and serving as a public academic. Mascott admitted she voted in Maryland, did not hold a Delaware driver's license, and only recently gained admission to practice in the Third Circuit. While she mentioned owning a car insured in Delaware and having a summer house there, senators suggested that her ties remained relatively thin. The hearing also revisited her role on the board of the New Civil Liberties Alliance, a conservative legal organization. Senators raised concerns about its hiring of Jeffrey Clark, a controversial former Justice Department official. Mascott clarified that as one of roughly 24 advisory board members, she had no role in staffing decisions, and even stepped down when the group pursued litigation opposing a legal opinion she had authored. The sharpest exchange, however, came when Mascott's views on administrative law were highlighted. Senators noted her repeated criticism of the so-called administrative state, her support for overturning Humphrey's executor, her opposition to Chevron deference, and her endorsement of the major questions doctrine. Lawmakers argued these positions align closely with fossil fuel industry efforts to weaken regulatory authority. One senator directly asked how anyone opposed to fossil fuel interests could expect a fair hearing before her. Mascott responded firmly, emphasizing that as a judge she would not rule on policy, but instead apply the law impartially. She noted her history of working on cases involving parties with divergent policy stances, underscoring that her role would be to uphold the judicial oath of neutrality rather than advance industry interests. This clash encapsulates the broader debate surrounding federal judicial nominations today. Should nominees be evaluated primarily on courtroom experience, personal connections to the jurisdiction, or ideological positions on regulatory authority? Supporters argue Mascott's academic background, government service, and appellate advocacy qualify her, while critics worry about limited trial experience and strong anti-regulatory leanings. The confirmation process for Ms. Mascott is far from over, but these exchanges reveal the fault lines: experience versus ideology, impartiality versus industry alignment, and tradition versus political maneuvering. Whether she ultimately secures a seat on the Third Circuit will depend not only on her record, but also on how senators and the public interpret her answers. Thanks for watching the Hill Debate. Don't forget to like, share, and subscribe for more deep dives into the most important hearings shaping America's courts and policies.